Mr. Hall, you can do that. Yeah, yeah, Judge, should I get Mike in here to do the closing? Should I get Gravely in here to do the closing?
No, no. He gets very animated, too. He's... It's 8:30. I'm going to call Allan Brown.
Oh, hang on, we need your clerk.
She's not going to be out here for the jury
Oh,
instruction.
okay.
Yeah.
That's why she's running away.
State of Wisconsin versus Allan Brown, 21 CF 1344. Let's have the appearances, please.
Good morning. State appears by Alexander Smathers.
Allan Brown appears in person with attorneys Addison Kuhn and McKenna Quinter.
Good morning. The jury is not in the courtroom. We are going to do jury instructions. I'm going to go through each instruction, but I want to start out with page 6 of the instructions, the statements of the defendant. And the reason I bring that up, I went through the file and I didn't see any documentation for anybody requesting any sort of hearing as to the statements of the defendant. I know they gave him his Miranda warnings. We know that. We know there's no written statement. I know the statements that he made to the deputy when he was in the hospital. She was there to guard him. She wasn't there to take any sort of statement or do any sort of interrogation. And those, obviously, I would consider spontaneous statements. She wasn't questioning him. He just on his own talked to the deputy, and I don't have a problem with that. But I'm looking at my notes, and that is Investigator Stephen Strom. He is
Storm, Your Honor.
20, what is it?
Storm.
Storm, thank you. 23. And the attorneys can correct me, but my recollection is he went to talk to the defendant in the hospital, and he's an investigator. We know the defendant's in custody, and he did say that he did Miranda warnings, but there was a conversation that took place prior to that that I have a problem with. And I believe the state asked the question, did he ask about whether there was a video or was this incident being recorded? And there was a back and forth conversation. I have a problem with those statements because we never had any sort of hearing, whether they were voluntary or whether there was a question asked. That's my issue with those statements. If you want to respond as to that, you can.
Well, Your Honor, I do think they were proper. The officer went there to, yes, to speak to the defendant. And before he could read him his Miranda rights, he, introduced himself. And the defendant began asking questions. And case law is clear, and I didn't research this.
I know case law, but here's the problem. That hearing as to those facts has to take place outside of the presence of the jury. prior to the statements coming in.
If there's a challenge, and there never was.
It's automatic. It's not discretionary. And case law is clear on that. They don't have to ask for it. And that's why sometimes when the state wants to use a statement, they'll tell the judge, wait a minute, even though the defense has not asked for one, we want a hearing on it. So my solution, I'm going to strike all that testimony.
Okay.
And I'm going to tell the jury, just as to Stephen Storm, whatever conversations they had is all stricken from the record. Now, his other testimony as to what he testified as to, he prepared the drone and he took photos, that's totally different. But any actual conversation that they had, I'm going to strike.
Your Honor, it was actually Investigator Willis who interviewed the defendant, not Investigator Storm.
All right, then I stand corrected. Let me get to that, his notes. Wasn't he one of the last witnesses on day one?
Yes. And Investigator Storm was yesterday.
All right.
Your recollection of the testimony is correct. It's just the name of the witness.
I got the witness mixed up? All right. Well, I got the important part right. Let me get to my notes. Is there any, the defense have an objection to me striking those statements?
No, that's fine.
Yeah, I'm going to, that's the first thing I'm going to tell the jury when they come out, that as only as to that witness. Oh, here we go. Andrew Willis, investigator. So you're telling me that's the officer that talked to the defendant in the hospital?
Yes.
All right. Okay, let's start out in order then, since we have that completed. And then for Ms. Mathers, I have the stricken instruction is like one line. I
Okay.
just printed it off. You don't have to reprint all your instructions, and I'll just read it.
Okay, thank you.
So, all right, let's start out with the jury instruction, and I'll ask the defense any objection to the instructions, and I'll go through each one. Any objection to the opening instructions?
No.
Any objections to reading evidence?
No.
Any objections to reading circumstantial evidence?
No.
Any objection to reading information, not evidence?
No.
Any objection to weight of the evidence?
No.
Jurors' knowledge?
No.
Exhibits?
No.
Transcripts not available for deliberations?
No.
Police reports?
No.
Objections, evidence received over objections?
No.
Remarks of counsel?
No.
Closing arguments of counsel?
No.
Expert opinion testimony, general?
I guess I don't know did we qualify anyone as an expert in the case?
I think we had the doctor
And crime lab
and
analyst.
the crime lab.
That's fine, yeah.
I would consider those experts because they gave opinions.
That's fine.
All right. Credibility of witnesses,
No.
statements of the defendant.
No.
Defendant elects not to testify.
No.
Evidence of other conduct.
No.
One defendant, 9 counts.
No.
Did you go over each count?
I did, yes.
Right. Do we have the dates and correctly from the state?
Yes.
All right. All right, then we're up to burden of proof, presumption of innocence. Any objection?
No.
Verdict submitted for one defendant, multiple counts, separate verdict on each count. Any objection to that?
No.
Any objection to closing instructions?
No.
Unanimous verdict, selection of presiding juror?
No.
And has the defense looked at all the verdict forms?
I did, yes.
Any objection to the verdict forms?
No.
All right. Any other instructions that the defense wishes the court to read to the jury?
No, I don't believe
Any
so.
other instructions that the prosecution wishes the court to read to the jury?
No, Your Honor.
All right. Any idea how long your closing is going to go, Ms. Mathers?
20 minutes?
All right. Any idea how long your closing is going to go?
It's about 3.5 minutes.
I didn't hear you.
About 3.5 minutes.
All right. And then you're going to do a rebuttal?
Briefly.
Okay. I have to read my instructions. It's probably going to take longer than anything. And then we'll try to get everything done and let them start deliberating. And again, we'll bring in lunch for the jury. Anything else we need to address before we take a short break?
I just want to make sure the verdict forms you have, Your Honor, have the correct year.
Okay, let me, and what, as to the dated?
Yes, all the verdict forms, originally I had March 2022. Attorney Kuhn pointed that out. I fixed it and resent it to your
Let
clerk.
me go through each one here. All right, they all have 2023.
Excellent, thank you.
All right, we can take a short break and we'll wait for the jury to show up. Are you ready? All right, are we ready? We can bring the jury out? All right. Take your seats. We're going to go on the record on Allan M. Brown, 21 CF 1344. Let's have the appearances, please.
Good morning. State appears by Alexander Smathers.
Allan Brown appears in persons with attorney Addison Kuhn and McKenna Quinchett.
Good morning. The jury is back in the courtroom. Thank you for coming on time this morning, ladies and gentlemen. Before we do our jury instructions and closing arguments, I want you to know that I am going to strike some testimony. And if you remember from voir dire on Monday, you took an oath and you promised to listen to the evidence, listen to my jury instructions. This testimony that I'm striking is from Tuesday, May 28th. It was late in the afternoon. It was a investigator from the Racine Sheriff's Department, Andrew Willis, testified that he went to the hospital and he talked to the defendant for a very short period of time, and there was a conversation. So any testimony as to that conversation between the investigator and the defendant, I am striking, and you will not consider. I will read the jury instruction to you right now. I'll repeat it later on, but stricken testimony means during a trial the court has ordered certain testimony to be stricken. Disregard all stricken testimony. So I am ordering you not to consider that testimony, that conversation between that investigator and the defendant. Okay, with that, I'm going to read my instructions. You'll have the hard copy when you go in the back, but I have to read the instructions to you. Once I'm done with my instructions, the attorneys will do their closing arguments, and because the state has the burden of proof, they get to talk once. I'm sorry, they get to talk twice. The defendant only gets to talk once, so you understand what's going on. So with that, and we don't have any pads or pencils, right? Nobody's got their pads. Give them to the bailiff. You'll get your pads back later, but you can't have them during closing, okay? Thank you. All right, members of the jury, the court will now instruct you about the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all these instructions. Regardless of any opinion you may have about the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply the law to the facts in the case which has been properly proven by the evidence. Consider only the evidence received during this trial and the law is given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. Evidence. Evidence is first the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Circumstantial evidence. It's not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Information, not evidence. And information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The weight of the evidence. The weight of the evidence does not depend on a number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even several other witnesses. Jurors' knowledge. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. Exhibits. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Transcripts not available for deliberations. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. As such, you should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and the testimony introduced during the trial. Police reports. During the course of a trial, the attorneys may refer to or use police reports with witnesses. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to the police reports. Objections. Evidence received over objections. Attorneys for each side have the right and a duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Remarks of counsel are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. Closing arguments of counsel. Consider carefully the closing arguments of the attorneys, but their arguments are conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. Expert opinion, testimony, general. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give the opinion, you should consider the qualifications and the credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. The credibility of witnesses. It's the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses, and the weight to be given to their testimony. and determine the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness had an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during a trial which tend either to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourself the reliability of things people say to you. You should do the same thing here. Statements of the defendant. The state has introduced evidence of statements which claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things: whether the statement was actually made by the defendant, or only so much of a statement as was actually made by a person may be considered as evidence, whether the statement was actually reinstated here at trial, whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence, and determine how much weight, if any, the statements deserve. Defendant elects not to testify. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Evidence of other conduct. Evidence has been presented regarding other conduct of the defendant for which the defendant is not on trial. Specifically, evidence has been presented that the defendant was involved in 2 homicides in Chicago, Illinois, in the early morning hours of October 21st, 2021. You should only consider this conduct for the purpose of context or background, that is, to provide a more complete presentations of the evidence relating to the offenses charged. You may not consider this evidence to conclude that the defendant has certain character or a certain character trait, and that the defendant acted in conformity with that trait or character with respect to the offense charged in this case. You may consider this evidence only for the purpose I have described, giving it the weight you determine it deserves. It is not to be used or conclude that the defendant is a bad person or for that reason is guilty of the offenses charged. One defendant, there's 9 counts. Count 1, first-degree reckless endangering safety by use of a dangerous weapon. The first count of the information charges that Allan M. Brown, on or about Thursday, October 21st, 2021, in the village of Bristol, County, Kenosha, the state of Wisconsin, did recklessly endanger the safety of Juan D. Avila under circumstances which show utter disregard for human life, contrary to Section 941.30 sub 1, 939.63 sub 1b of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. The statutory definition of the crime: first-degree reckless endangering safety, as defined in 941.30 sub 1 of the Wisconsin Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. The state's burden of proof before you may find a defendant guilty of first-degree reckless endangering safety. The state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present. The elements of the crime the state must prove: number 1, the defendant endangered the safety of another human being, Juan D. Avila. 2, the defendant endangered the safety of Juan D. Avila by criminally reckless conduct. Criminally reckless conduct means conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury, which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all the facts and circumstances relating to the conduct. Consider also the defendant's conduct after the alleged act to have endangered safety to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the act alleged to have endangered safety occurred. The jury's decision. If you are satisfied beyond a reasonable doubt that all 3 elements of this offense are present, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 1 of the information alleges not only that the defendant committed the crime of first-degree reckless endangering safety, but also that the defendant did so while using a dangerous weapon. If you find the defendant guilty, you must answer the following question. Did the defendant use a dangerous weapon in committing this crime? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question no. Count 2, first-degree reckless endangering safety by use of a dangerous weapon. The second count of the information charges that Allan M. Brown, on or about Thursday, October 21st, 2021, in the village of Bristol, the county Kenosha, the state of Wisconsin, did recklessly endanger the safety of Colin Coultrip under circumstances which showed utter disregard for human life, contrary to Section 941.30 sub 1, 939.63 sub 1b of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Statutory definition of the crime: first-degree reckless endangering safety as defined in 941.30 sub 1 of the Criminal Code of Wisconsin is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find a defendant guilty of first-degree reckless endangering safety, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present. The elements of the crime that the state must prove. Number 1, the defendant endangered the safety of another human being, Colin Coultrip. The defendant endangered the safety of Colin Coultrip by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial. The defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for human life, and all other facts and circumstances relating to the conduct. Consider also the defendant's conduct after the act alleged to have endangered safety, to the extent that it helps you decide whether or not the circumstances show utter disregard for human life at the time the act alleged to have endangered safety occurred. The jury's decision. If you are satisfied beyond a reasonable doubt that all three elements of this offense were present, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 2 of the information alleges not only that the defendant committed the crime of first-degree reckless endangering safety, but also that the defendant did so while using a dangerous weapon. If you find the defendant guilty, you must answer the following question. Did the defendant use a dangerous weapon in committing this crime? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder. Before you may answer this question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question no. Count 3 of the information. First-degree reckless endangering safety by use of a dangerous weapon. The third count of the information charges that Allan M. Brown, on or about Thursday, October 21st, 2021, in the village of Bristol, the county Kenosha, the state of Wisconsin, did recklessly endanger the safety of Terry Tifft under circumstances which showed utter disregard for human life, contrary to Section 941.30 sub 1, 939.63 sub 1b of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. The statutory definition of the crime, first-degree reckless endangering safety, as defined in 941.30 sub 1 of the Wisconsin Criminal Code, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. State's burden of proof, for you may find a defendant guilty of first-degree reckless endangering safety. State must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. The elements of the crime the state must prove: number one, the defendant endangered the safety of another human being, Terry Tifft. 2, the defendant endangered the safety of Terry Tifft by criminally reckless conduct. Criminally reckless conduct means conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial. The defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent and protracted loss or impairment of the functions of any bodily member or organ or other serious bodily injury. Number 3, the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. Consider also the defendant's conduct after the act alleged to have endangered safety, to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the act alleged to have endangered safety occurred. The jury's decision. If you are satisfied beyond a reasonable doubt that all three elements of this offense are present, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 3 of the information alleges not only that the defendant committed a crime of first-degree reckless endangering safety, but also that the defendant did so while using a dangerous weapon. If you find the defendant guilty, you must answer the following question. Did the defendant use a dangerous weapon in committing this crime? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question no. Count 4, possession of a firearm. The fourth count in the information charges an Allan M. Brown on or about Thursday, October 21st, 2021, Village of Bristol, the County Kenosha, the State of Wisconsin, did possess a firearm, having been convicted of a crime elsewhere that would be a felony if committed in this state, contrary to Section 941.29 1MB of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. Statutory definition of the crime. Section 941.29 sub 1M of the Criminal Code of Wisconsin is violated by a person who possesses a firearm if that person has been convicted of a felony. The state's burden of proof. Before you may find a defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements are present. The elements of the crime that the state must prove. Number one, the defendant possessed a firearm. Firearm means a weapon which acts by force of gunpowder. It's not necessary that the firearm was loaded or capable of being fired. Possess means that the defendant not only had actual physical control of a firearm. It's not required that a person own an item in order to possess it. What is required is that the person exercise control over the item. The defendant had been convicted of a felony before October 21st, 2021. The parties have agreed that the defendant was convicted of a felony before October 21st, 2021, and you must accept this as conclusively proved. The jury's decision. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 5, harassment of police animals. Fifth count of the information charges at Allan M. Brown on or about Thursday, October 21st, 2021, in the Village of Bristol, the County Kenosha, the State of Wisconsin, did intentionally strike an animal by using a dangerous weapon. Knowing that that animal is the victim is used by law enforcement agencies to perform agency functions or duties and cause injury to that animal, contrary to Section 951.182M of the Wisconsin statutes, and contrary to Section 951.0951C of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. Statutory definition of the crime. Section 951.095 and 951.182M of the Criminal Code of Wisconsin are violated by one who causes injury to an animal that is used by law enforcement agency to perform agency functions by intentionally striking, shoving, kicking, or otherwise subjecting the animal to physical contact, and knows that the animal is used by law enforcement agency to perform agency functions. State's burden of proof. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements are present. The elements of the crime that the state must prove. Number one, Canine rigs was an animal used by a law enforcement agency to perform agency functions. Number 2, the defendant knew that the animal was used by law enforcement agency to perform agency functions. The defendant intentionally struck, shoved, kicked, or otherwise subjected the animal to physical contact. Striking, shoving, kicking, or otherwise subjecting the animal to physical contact caused injury to the animal. The jury's decision. If you are satisfied beyond a reasonable doubt that all 4 elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 6, mistreating an animal, use of a dangerous weapon. The 6th count of the information charges that Allan M. Brown, on or about Thursday, October 21st, 2021, in the village of Bristol, the county Kenosha, the state of Wisconsin, did intentionally treat in a cruel manner an animal, canine rigs, he knew was being used by a law enforcement agency to perform agency functions or duties, causing injury to that animal, contrary to Section 951.02 of the Wisconsin statutes and contrary to 939.631C of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. The statutory definition of the crime, mistreating an animal, as defined in 951.02 and 951.18 of the Criminal Code of Wisconsin, is committed by one who intentionally treats an animal in a cruel manner. State's burden of proof. Before you may find a defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. The elements of the crime that state must prove. Number 1, the defendant treated an animal, canine rigs, in a cruel manner. Cruel means causing unnecessary and excessive pain or suffering or unjustifiable injury or death. Number 2, the defendant intentionally treated canine rigs in a cruel manner. Intentionally requires that the defendant acted with the mental purpose to treat the animal in a cruel manner or was aware that the conduct was practically certain to cause that result. The jury's decision. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant intentionally treated an animal in a cruel manner, you must answer the following question. Did the defendant cause injury to that animal and know that that animal was used by a law enforcement agency to perform agency functions or duties? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the answer to that question is yes. If you are not so satisfied, you must answer the question no. Count 6 of the information alleges not only that the defendant committed the crime of mistreating an animal, but also the defendant did so while using a dangerous weapon. If you find a defendant guilty, you must answer the following question. Did the defendant use a dangerous weapon in committing this crime? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question no. Count 7, failure to comply with an officer's attempt to take a person into custody. The 7th count of the information charges that Allan M. Brown, on or about Thursday, October 21st, 2021, in the village of Bristol, the county Kenosha, did intentionally refuse to comply with an officer's lawful attempt to take him or her into custody and retreats or remains in a building or place and through action or threat attempted to prevent the officer from taking him or her into custody while doing each of the above, remain or become armed with a dangerous weapon or threaten to use a dangerous weapon regardless of whether he had a dangerous weapon, contrary to Section 946.1 15 sub 2 of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The statutory definition of crime, 946.415 of the Criminal Code of the Wisconsin, is violated by a person who intentionally does all of the following: refuses to comply with the officer's lawful attempt to take the person into custody, retreats or remains in a building or place, and through action or threat attempts to prevent the officer from taking the person into custody, and remains or becomes armed with a dangerous weapon or threatens to use a dangerous weapon, regardless of whether the person had a dangerous weapon. The state's burden of proof. Before you may find a defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. The elements of the crime the state must prove: number one, the defendant intentionally refused to comply with the officer's lawful attempt to take the defendant into custody. Intentionally requires the defendant knew that an officer was lawfully attempting to take the defendant into custody. Number two, the defendant intentionally retreated or remained in a building or place and through action or threat intentionally attempted to prevent the officer from taking the defendant into custody. Number three, while committing elements 1 and 2, the defendant intentionally remained or became armed with a dangerous weapon. Deciding about intent and knowledge. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, or statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. The juror's decision. If you are satisfied beyond a reasonable doubt that all three elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 8, driving or operating a vehicle without the owner's consent, use of a dangerous weapon. The 8th count of the information charges that Allan M. Brown, on or about Thursday, October 21st, 2021, in the village of Bristol, the county Kenosha, the state of Wisconsin, did intentionally drive or operate a vehicle, a 2016 Buick Encore, without consent to the owner, Miguel Padilla Jr., during the carjacking of this vehicle, contrary to section 948.23 sub 3 and 939.63 1C of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. The statutory definition of the crime. Driving or operating a vehicle without owner's consent, as defined in 943 sub 23 sub 3 of the Criminal Code of Wisconsin, is committed by one who intentionally drives or operates a vehicle without consent of the owner. The state's burden of proof. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. The elements of the crime the state must prove: number one, the defendant intentionally drove or operated a vehicle without consent of the owner. Drive means to exercise physical control over the speed and direction of a vehicle while it is in motion. Operate means that the physical manipulation or activation of any of the controls of the vehicle is necessary to put it into motion. The defendant knew that the owner of the vehicle did not consent to the driving or operating the vehicle. Deciding about intent and knowledge. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in his case bearing upon intent and knowledge. Jury's decision. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 8 of the information alleges not only that the defendant committed the crime of drive or operate a vehicle without owner's consent, but also the defendant did so while possessing a dangerous weapon. If you find the defendant guilty, you must answer the following question. Did the defendant possess a dangerous weapon while committing this crime? Dangerous weapons means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while possessing a dangerous weapon. If you're not so satisfied, you must answer the question no. Count 9. Attempted escape from custody resulting from legal arrest for a crime. The 9th count in the information charges at Allan M. Brown on or about Friday, October 29, 2021, Village of Pleasant Prairie, the County, Kenosha, the state of Wisconsin, attempted to intentionally escape from custody, having been lawfully arrested for a crime contrary to Section 946.42 sub 3A and 939.32 of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Statutory definition of the crime. The crime of attempted escape from custody is defined in 939.32 and 946.42 sub 3 of the Criminal Code of Wisconsin is committed by a person who, with intent to commit escape from custody, does acts towards the commission of that crime which demonstrate unequivocally under all the circumstances that he has formed that intent and would have committed the crime except for the intervention of another person or some other extraneous factor. State's burden of proof. Before you may find a defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements are present. The elements of the crime the state must prove. Number one, the first element of attempted escape from custody requires that the defendant intended to commit the crime of escape from custody. The crime of escape from custody is committed by one who intentionally escapes from custody when that custody resulted from a legal arrest for a crime. The elements of escape from custody are as follows. Number one, the defendant was in custody. Custody means the physical control of a person by a peace officer. A person also is in custody when temporarily outside of an institution for purposes of receiving medical care. Number two, the custody resulted from a legal arrest for a crime. An arrest for a crime is legal when the officer making the arrest has reasonable grounds to believe that person is committing or has committed a crime. First-degree reckless endangering safety, possession of a firearm by an out-of-state felon, harassment of a police animal, mistreatment of an animal, failure to comply with an officer's duty to take into custody, and drive or operate a motor vehicle without owner's consent are all crimes. The defendant escaped from custody. Escapes means to leave in any manner without lawful permission or authority. The escape from custody was intentional. This requires that the defendant intentionally escape from custody, that is, that the defendant had the mental purpose to escape. The crime charged of the defendant in this case, however, is not escape from custody as defined, but an attempt to commit the crime of escape from custody. The second element of attempted escape from custody requires the defendant did acts towards the commission of the crime of escape from custody, which demonstrates unequivocally under all the circumstances that the defendant intended to and would have committed the crime of escape from custody except for the intervention of another person or some other extraneous factor, meaning unequivocally. Unequivocally means that no other inference or conclusion can reasonably or fairly be drawn from the defendant's acts under the circumstances. Meaning of another person. Another person means anyone but the defendant and may include the intended victim. Meaning of an extraneous factor. An extraneous factor is something outside the knowledge of the defendant or outside the defendant's control. Deciding about intent. You cannot look into a person's mind to find intent. Intent must be found and found at all from all the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. The jury's decision. If you are satisfied beyond a reasonable doubt that all the elements of the attempted escape from custody have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Burden of proof and a presumption of innocence. In reaching your verdict, examine the evidence with care and caution, act with judgment, reason, and prudence. Presumption of innocence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The state's burden of proof. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. Reasonable hypothesis. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The meaning of reasonable doubt. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt it would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from a fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Verdict submitted for one defendant, multiple counts, separate verdict on each count required. The following forms of verdict will be submitted to you concerning the charges against the defendant, Allan M. Brown. Count 1, one reading. We, the jury, find the defendant, Allan M. Brown, not guilty of first-degree reckless endangering safety, to wit, Juan Avila, as charged in count 1 of the information. Another reading. We, the jury, find the defendant, Allan M. Brown, guilty of first-degree reckless endangering safety, to wit, Juan Avila, as charged in count 1 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Yes or no, mark 1. Count 2. One reading. We, the jury, find the defendant, Allan M. Brown, not guilty of first-degree reckless endangering safety, to wit, Colin Coultrip, as charged in count 2 of the information. Another reading. We, the jury, find the defendant, Allan M. Brown, guilty of first-degree reckless endangering safety, to wit, Colin Coultrip, as charged in count 2 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Yes or no, check 1. Count 3, one reading. We, the jury, find the defendant, Allan M. Brown, not guilty of first-degree reckless endangering safety, to wit, Terry Tifft, as charged in count 3 of the information. Another reading. We, the jury, find the defendant, Allan M. Brown, guilty of first-degree reckless endangering safety, to wit, Terry Tifft, as charged in count 3 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Yes or no? Check 1. Count 4. One reading. We, the jury, find the defendant, Allan M. Brown, not guilty of possession of a firearm as charged in count 4 of the information. Another reading. We, the jury, find the defendant, Allan M. Brown, guilty of possession of a firearm as charged in count 4 of the information. Count 5. One reading, we the jury find the defendant, Allan M. Brown, not guilty of a harassment of police animals as charged in count 5 of the information. Another reading, we the jury find the defendant, Allan M. Brown, guilty of harassment of police animals as charged in count 5 of the information. Count 6. One reading, we the jury find the defendant, Allan M. Brown, not guilty of mistreating an animal as charged in count 6 of the information. Another reading, we the jury find the defendant, Allan M. Brown, guilty of mistreating an animal as charged in count 6 of the information. Please answer the following question. Did the defendant cause injury to the animal and know that the animal was used by a law enforcement agency to perform agency functions or duties? Yes or no? Check 1. Did the defendant use a dangerous weapon in committing this crime? Yes or no? Check 1. Count 7. We, the jury, find the defendant, Allan M. Brown, not guilty of failure to comply with an officer's attempt to take a person into custody as charged in count 7 of the information. Another reading, we, the jury, find the defendant, Allan M. Brown, guilty of failure to comply with an officer's attempt to take a person into custody as charged in count 7 of the information. Count 8. One reading, we the jury find the defendant, Allan M. Brown, not guilty of driving or operating a vehicle without owner's consent as charged in count 8 of the information. Another reading, we the jury find the defendant, Allan M. Brown, guilty of driving or operating a vehicle without owner's consent as charged in count 8 of the information. Please answer the following question. Did the defendant possess a dangerous weapon while committing this crime? Yes or no? Check 1. Count 9. One reading, we the jury find the defendant, Allan M. Brown, not guilty of attempted escape from custody as charged in count 9 of the information. Another reading, we the jury find the defendant, Allan M. Brown, guilty of attempted escape from custody as charged in count 9 of the information. It is for you to determine whether the defendant is guilty or not guilty of each offense charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charge in one count must not affect your verdict on any other count. I'm going to read to you again the stricken testimony instruction. During this trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. I have further instructions to read that are not that long, but I will do those after the attorneys do their closings. With that, the state can do their closing. If we can move the podium and have a microphone available.
No, just the podium. Thank you, though. Good morning, ladies and gentlemen. First, I want to thank you very much for your time and attention to this case. This was 2 very long days of testimony. The defendant is presumed innocent, has a constitutional right to a jury trial, so I thank each and every one of you for being a part of that process. Throughout these last 2 days, the state presented 20 witnesses and over 20 exhibits for you to view. I told you on Tuesday that the majority of this case, counts 1 through 8, occurred in 33 seconds. You saw those 33 seconds over and over and over and over again. Again, as I said, that's the beauty of technology. You saw a body camera, surveillance video, squad video. Not only of those 33 seconds in real time, but also slowed down and stabilized. And you saw the investigation that happened thereafter. Based on all that evidence, The state has undoubtedly proved this case well beyond a reasonable doubt. So let's look at the counts charged. The first 3 counts are first-degree recklessly endangering safety. The state has proven beyond a reasonable doubt that the defendant endangered the safety of deputies Coultrip, Avila, and Tifft when he recklessly fired at officers on 2 occasions. You heard testimony from Deputy Coultrip about that very first shot where they're running up the driveway and the defendant produces a firearm and with his right hand puts it between his left arm while looking back and recklessly fires behind him while moving at the 3 deputies behind him. Deputy Coultrip testified with clear memory how he heard the shot, how he saw the gas come from the firearm, and how it was at him. You heard testimony from Deputy Avila, how when the defendant was on the ground with canine rigs, the defendant fired towards officers. Deputy Avila, again, with clear memory, testified how he saw the flash of the muzzle, how it was at him, and how, for a brief moment, he thought that he had been hit. He talked about how he paused, kind of did an assessment, thought, maybe I'm hit in the head, maybe this is it, I better at least get a shot off. And you see that in his body cam, how he's running and then kind of hesitates backwards and pulls up his firearm. That's him thinking that he's been hit, having seen that flash of a muzzle in his direction. And you heard testimony from Deputy Tifft, who was within feet of the other officers, and how when the defendant again was on the ground with his canine, he saw the defendant shoot at him. This is criminally reckless conduct. Shooting at anyone creates a risk of death or great bodily harm. The defendant knew that when he fired willy-nilly behind him towards officers and when he fired at them head-on while on the ground. He was aware that that conduct created a risk to those officers. And that risk showed utter disregard for human life. The defendant did not care if those officers died. He did not care if they were struck or injured. He had only one goal in mind, and that was to get out of there. As I said on Tuesday, he had gotten out of Chicago, he had gotten to Kenosha in this stolen vehicle, and he was looking to move on. He did not care about the life or safety of anyone who stood in his way. So when he fired at officers, it was for utter disregard of their life. And he did so while armed with that weapon. And we know that that weapon was a firearm. We know that it worked. We know that it fired 3 shots. We know that because we found 2 of the casings and because of what the officers saw. And I submit to you, he would have kept firing had that gun not jammed, had there not been a misfeed which prevented him from firing further. Count 4 is possession of a firearm. I think that one's pretty clear. He clearly had that firearm and used it against officers as well as canine rigs, which leads me to count 5, harassment of a police animal. Again, I think there's absolutely no doubt that the defendant intentionally struck canine rigs with a bullet, knowing full well that canine rigs was a working law enforcement animal and that he caused him injury. As the defendant was fleeing from officers, he looked behind him. He saw the officers. That's why he fired that first round. And when he looked behind him, he had to have seen canine rigs on a leash being held by Deputy Tifft, who was in fully marked law enforcement uniform, and they were operating fully marked Kenosha County Sheriff's Deputy squad cars. So the defendant knew full well Canine Riggs was a law enforcement animal. And when Canine Riggs did his job, did what he's been trained to do for the last 10 years, and that is bite and hold the defendant, again, knowing full well he was an officer, took his firearm, pointed it directly at Canine Riggs' head, and shot. But for the grace of God, Canine Riggs is still here today. But he did sustain injuries. You saw pictures of his injuries, the entrance wound to the middle of the dog's forehead, and the exit wound behind the right ear. You heard testimony from the treating veterinarian who talked about how his demeanor was dull, how he required anticonvulsant medication, antibiotics. He required a 3-day hospital stay, how they were worried about abscess, how he suffered the human equivalent of a concussion with a bruising to the inside of his brain. And that was undoubtedly caused by the defendant and done so intentionally. And that also goes to count 6, mistreatment of animal while armed. Again, he treated Canine Riggs in a cruel manner by shooting him. I don't know what could be more cruel than shooting an animal. He shot him again, point blank, in the head, intentionally, causing unjustifiable injury and unnecessary pain and suffering. Again, he knew that Canine Riggs was a police dog, and he used a weapon to cause him that injury, pain, and suffering. Count 7 is failure to comply with officers' attempt to take him into custody. Again, all the evidence has proven this beyond a reasonable doubt. The defendant intentionally refused to comply with officers' attempts to take him into custody when he remained at Benson's Corners and retreated and remained armed while doing so. Again, Mr. Brown had no intention of going into custody. He had no intention of being held responsible for any crimes committed by him. He had one goal: to get out of there and to escape. So regardless of lawful commands, regardless of a canine holding him down, he fled and refused to comply with their attempts to take him into custody. It was only after officers did what they hoped they never have to do on a job, which is shoot him. It was only after he was shot that he was taken into custody. Count 8 is operating a motor vehicle without owner's consent while use of a dangerous weapon. Again, I think the evidence has shown beyond a reasonable doubt that the defendant drove or operated Miguel Padilla Jr.'s vehicle without his consent. You heard testimony from Chicago Police Department detectives as well as local law enforcement agencies. The defendant knew he did not have consent to operate that vehicle based on the way that vehicle was procured. And he knew that. And he clearly possessed a firearm while operating that vehicle without consent. Not only did he have the firearm on his person when he fired at officers and Canine Riggs, in his backpack within the vehicle were additional ammo, I believe 15 rounds in one pocket and another round in another pocket, and there was also a casing found on the ground. So he definitely and certainly possessed that firearm while operating that vehicle without consent. Again, all 8 of those counts within those 33 seconds. The last count occurred October 29th, several days later. While in custody, he was receiving medical treatment for the wounds he had sustained while fleeing from officers. He had been arrested for counts 1 through 8 and was clearly in custody and being guarded by Racine County Sheriff's deputies. You heard testimony from Deputy Beal, how he was target glancing, especially that fire exit or fire stairwell at the end of the hall. On October 29th, doctors told him that he was ready to be discharged, and they were getting ready to transport him to the Racine County Jail, when again, the defendant tried one last time not to be held responsible for his actions. He took that opportunity when he was not leg shackled, or I'm sorry, not shackled to, arm shackled to the bed to try and run. You heard testimony from Deputy Beal, how he lunged forward, how she thought he was lunging at her, but instead he ran past her, pushing her aside, and ran for the door. But for Deputy Beal's quick actions, he would have been successful. But Deputy Beal immediately turned around and basically tackled him to the ground. Tackled him to the ground, put him back into custody. And again, absolutely no doubt was what his intention was there. Again, he had escaped from Chicago, he had tried to escape from Kenosha, and he was trying one more time. Ladies and gentlemen, jury, with all the evidence you've heard, the testimony, the exhibits, the body camera, there is absolutely no doubt in this case that the defendant is guilty, let alone a reasonable one. And there is absolutely no reasonable hypothesis in this case that's consistent with the defendant's innocence on any of these counts. So based on all that, ladies and gentlemen, I ask that when you go back in the jury room, that you find the defendant guilty of all 9 counts. Thank you.
Thank you. Let's have the defense closing. And if you could just state your name for the record so the transcript's correct.
McKenna Quinter. "33 seconds. From start to finish, the most important part of this case is 33 seconds. The state's correct in that. We heard a lot of testimony about those 33 seconds. We heard from Deputy Coultrip, Deputy Avila, Deputy Juan, and Deputy Tifft. They all came up here. They went over step by step by step their versions of what happened on that day. You heard lengthy testimony about it. But this incident wasn't lengthy. 33 seconds. It was quick, it was intense, it was stressful. All things that can leave a situation a little unclear, can make recall harder. But who could blame anyone for that in this type of situation, right? But even understanding that still leaves inconsistencies. There are not 4 victims in this case. There are 2. Christopher Johnson from the Wisconsin State Crime Lab came up here and testified to the evidence he collected. That's why he was on scene. That's his job. That's why the state brought him here to testify. He said they collected 2 .32 caliber shell casings. The state even asked, it's normal to have missing shell casings, right? He says, no, it's not normal. They used metal detectors, canines. They were on their hands and knees searching through the grass. And no one finds a third .32 caliber shell casing. Deputy Conley says, maybe it got stuck in a boot. Maybe. 2 shots. 2 .32 caliber shell casings. The state wants you to believe that there are 4 victims, that 1 bullet from 1 gun went in the direction of 3 officers. 3 officers who, by their own testimony, were in different directions from Mr. Brown. Some said 20 feet away from one another. Deputy Coultrip said 10 to 20 yards, depending on which officer you're talking about. But a substantial distance apart. It is not substantially likely that 1 bullet fired in one direction is going to endanger the safety of 3 people who are such great distances apart. And your common sense will tell you that. You've been told you can use your common sense. Your common sense will tell you that a bullet fired in one direction is not just going to veer 20 feet to the left. It's not going to go 10 yards to the right. And if you don't trust your common sense, Deputy Conley actually testified to that a bullet fired in a direction, it will indeed go straight. In fact, the only testimony we have about which direction this bullet was fired is contradictory. 2 shots, 2 shell casings. But Deputy Coultrip says he fired directly at me. Deputy Avila says, no, he fired at me. He stopped. He had to check himself. He fired at Deputy Avila. And Deputy Tifft said, no, he fired at K-9 Riggs. And the state says just pick one. Had to go towards somebody. Beyond a reasonable doubt, just pick one. I'm not here to tell you that you have to approve of Mr. Brown's actions. That's not why you're here. Your job is to hold the state to their burden, beyond a reasonable doubt. And they're telling you beyond a reasonable doubt, just pick one. That's enough for those first 3 counts. At the start of this case, my co-counsel came up here and he said he asked you to keep an open mind, to listen to the testimony, to watch it, and you've done that over the last 2 days. That is exactly what you did. And you saw the inconsistencies and you heard them. He also asked you to hold the state accountable to their burden beyond a reasonable doubt. And I'm here to ask you to do the same thing, to hold the state accountable, to hold them to that burden of beyond a reasonable doubt, and ask that you find Mr. Brown not guilty of these charges.
Thank you. The state's rebuttal.
Thank you, Your Honor. I'll be brief. Attorney Quinter indicated that this was a quick, intense, and stressful situation, which leaves inconsistencies in testimony. And I agree. But it doesn't leave inconsistencies in digital evidence. And that's why I had you watch the body camera over and over and over again, almost ad nauseum at the point we were done. Because while officers are trying to remember something that happened quickly and trying to remember it over a year later, again, body camera and video evidence doesn't lie. And that evidence, if you listen to it carefully, as Investigator Conley did over 35 times, shows you that the defendant fired 3 shots. It shows you that he fired it at officers. And I submit to you that even the first shot is enough to find the defendant guilty, beyond a reasonable doubt, of the first 3 counts. Because anytime you fire behind you while running, without looking at moving targets, you endanger the safety of anyone in that area, because you could strike anyone. And all 3 officers were in that area. They were all chasing the defendant. And he recklessly endangered their lives, not only with that shot alone, but also the subsequent shot, of which there is clear testimony. So we are not asking you to speculate. We are not asking you to guess. We are asking you to follow the evidence, which in this case shows beyond a reasonable doubt that the defendant is guilty. Thank you.
All right, the closing of arguments have now been completed. Members of the jury, the duties of counsel in the court have been performed. Case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. Time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You'll be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind as upright citizens. Render a just and true verdict. You are to decide only on whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. Unanimous verdict and selection of a presiding juror. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may be legally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it's important that you communicate with the court only by written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any question in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you reach a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, we will swear in the bailiffs if they could come forward. All right, the bailiffs have been sworn. You can follow the bailiffs. You can start your deliberations. Again, folks, we'll bring you in lunch today at 12 o'clock, okay? All right, the jury is outside of the courtroom. The attorney should be available. If you're going to go anywhere, leave a phone number, but if we have a question, I want you back here as soon as possible. And if we do have a question, we're going to have the defendant brought back also. So anything else before we break away from the state?
No, thank you.
Anything else from the defense?
No, thank you.
All right, again, leave a number. We want you back here immediately. Thank you. And we'll call for the defendant if we need him. All right. Please rise for the jury. You may take your seats. All right, we're going on the record on Allan M. Brown, 21 CF 1344. Let's have the appearances, please.
Good afternoon. State appears by Alexander Smathers.
Allan Brown, appears in person with Attorney Addison Kuhn.
Good afternoon. I'll ask the jury foreperson, do we have a verdict?
We do.
Can you hand all the paperwork to the bailiff? All right, I'm going to read each count into the record. State of Wisconsin versus Allan Brown, 21 CF 1344, verdict form. Count 1. We, the jury, find a defendant, Allan M. Brown, guilty of first-degree reckless endangering safety as to Juan Avila is charged in count 1 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Answer yes. Dated as 30th day of March 2023, signed by the foreperson. Verdict form as to count 2. We, the jury, find a defendant, Allan M. Brown, guilty of first-degree reckless endangering safety as to Colin Coultrip as charged in count 2 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Answer yes. Dated as 30th day of March 2023, signed by the foreperson. Verdict form as to count 3. We, the jury, find a defendant, Allan M. Brown, guilty of first-degree reckless endangering safety as to Tifft as charged in count 3 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Answer yes. Dated as 30th day of March 2023, signed by the foreperson. Verdict form as to count 4. We, the jury, find a defendant, Allan M. Brown, guilty of possession of a firearm as charged in count 4 of the information. As to count 5. We, the jury, find a defendant, Allan M. Brown, guilty of harassment of a police animal as charged in count 5 of the information. Dated as 30th day of March 2023, signed by the foreperson. Verdict form as to count 6. We, the jury, find a defendant, Allan M. Brown, guilty of mistreating an animal as charged in count 6 of the information. Please answer the following questions. Did the defendant cause injury to the animal and know that the animal was used by a law enforcement agency to perform agency functions or duties? Answer yes. Question, did the defendant use a dangerous weapon in committing this crime? Answer yes. Dated as 30th day of March 2023, signed by the foreperson. Verdict form, count 7. We, the jury, find a defendant, Allan M. Brown, guilty of failure to comply with an officer's attempt to take a person into custody as charged in count 7 of the information. Dated this 30th day of March 2023, signed by the foreperson. Verdict form, count 8. We, the jury, find a defendant, Allan M. Brown, guilty of driving or operating a vehicle without owner's consent as charged in count 8 of the information. Please answer the following question. Did the defendant possess a dangerous weapon while committing this crime? Answer, yes. Dated as 30th day of March 2023. Verdict form count 9. We, the jury, find the defendant, Allan M. Brown, guilty of attempted escape from custody as charged in count 9 of the information. Dated this 30th day of March 2023, signed by the foreperson. The defense wish have the court poll the jury.
Yes, please.
Right. What this means, folks, I'm going to ask you individually, and I'm just going to use numbers. I'll start out way in the back, closest to the door. You'll be number 1. I'll go through here 6. I'll come back. You'll be 7, and I'll go through 12. I have 9 verdicts. They all have answers to them. They all have verdicts to say guilty. They all have the answers to the questions that says yes. So I'll ask juror number 1, is this your verdict on all these verdicts as to Mr. Allan? Yes. Juror number 2, are these all your verdicts as to Mr. Allan? Yes. Juror number 3, are these all your verdicts as to Mr. Allan? Yes. Juror number 4, are these all your verdicts as to Mr. Allan? Yes. Juror number 5, are these all your verdicts as to Mr. Allan? Yes. Juror number 6, are these all your verdicts as to Mr. Allan? I'll go to the front. Juror number 7, are these all your verdicts as to Mr. Allan? Yes. Juror number 8, are these all your verdicts as to Mr. Allan? Yes. Juror number 9, are these all your verdicts as to Mr. Allan? Yes. Juror number 11, are these all your verdicts? No, I'm sorry. Juror number 10, are these all your verdicts as to Mr. Allan? Yes. Juror number 11, are these all your verdicts as to Mr. Allan? Yes. Juror number 12, are these all your verdicts as to Mr. Allan? So everyone in this jury, I'll ask you one more time, are these all your verdicts? Yes. All right, everybody answered yes for the record. Okay, I did poll the jury. You are excused then, folks. Thank you for your service. Don't forget your personal belongings. I thank you for everything. Have a good afternoon, okay? If you need anything, you can talk to the bailiff. All right, the jury is outside of the courtroom. Is there a motion by the state?
Yes, Your Honor, I move for judgment on the verdicts as well as revocation of any bond.
All right, as to judgment on the verdicts, there are 9 counts here. They're all guilty counts, so there'll be a judgment on all the verdicts with the enhancer questions that are in the verdict. The court's also, based on the charges and the convictions here, going to revoke the defendant's bond and set the matter for sentencing and order a pre-sentence investigation. I will have the clerk give you a date and let me know if the date will work.
May 19th at 10:30.
Is that good for the state?
That works, thank you.
Right. What about the defense?
I'm sorry, I'm not available that
All
morning.
right, we'll have to start over then.
May 25th at 10:30.
Good for the state?
Yes.
Defense?
That should be fine, thank you.
Okay. We'll see you then. Pre-sentence is ordered.
And that was 10:30, correct?
Yes.
All right, thank you.
Thank you.
Didn't make a move.
got to go, Jane.